This is a Marshall Enterprises presentation. Peace, family. Coming at you again. I got some info, and you'd have to excuse me. No, I'm not even making any excuses. I'm not even going to make no excuses. There's a ton of work on my plate, ton of things on my plate, and these videos be in my head. I have some of these jotted down on paper, and it's just a matter of finding the time to get this microphone, plug it up, and give you the presentation. So I'm trying to get more swift in my processes or swift in my delivery of these messages to you. So give me some time. I don't have a secretary. I don't have a team behind me. It's all me. So no excuses, but let's go. Let's go. Let's go. A good while ago, I was watching a video by You Are Law. You Are Law is a big asset to us being those that are trying to do what we need to do to fight our cases, win our cases, get these monkeys off our backs. Let me share my screen and show you the document that I recreated. And hopefully we do it right this time. And there we go. There we go. Okay, so as I was saying, yourlaw.org, team of, I'm not sure if they're attorneys. I'm not sure if they're paralegals. I'm not sure what their legal affiliation is. I'm really not sure at this particular moment. I knew it when I was watching the video. I just can't recall it right now. So I don't want to quote or misquote or misdefine, or, you know what I mean? I don't want to say there's something they're not. So anyway, in watching a video of theirs, the gentleman brought up a slide sheet, a slide or like a presentation showing this form that you see on the screen. And for me pausing the video and doing my little handiwork behind the scenes, I perfectly recreated that document. If you're not a member of yourlaw.org, these documents are not sent to you. You have to be a member, and they'll send you out these documents with no problem. But if you watch their videos and they're showing you the documents, you know, you can just recreate them on your own. This is what I do a lot of. Not that I don't spend any money, don't get me wrong. I'm kind of good at recreating documents. But I say all that to say, this outline is very, very, very thorough and very good. And I know it's going to help a lot of people on their cases, in their cases, all right? So I really don't want to read the entire document. I'm going to read as much as I need to read, but this short paragraph at the top, I'll start there, and I'll go through the document and show you the importance and how you need to add this to your arsenal. So I don't know if you're going to be able to slow this down and recreate it yourself, but hey, I did it, you can do it. You know, if I can do it, you can do it. All right, approach these situations, attack their defects. What are they saying? If you get a parking ticket, most of the time, if there's anything wrong with that parking ticket, you can bring that up or raise that issue, and the ticket is dismissed immediately. Because if one thing's wrong, everything's wrong. All right, so follow that thinking. Now, the same goes with when you are involved in a case, whether you are being the plaintiff or you're being the defendant. If anything is wrong with your argument, that tends to have a ricocheting effect on your case. So you want to try to dot your I's and cross your T's. Now, the goal of this approach is to find the defects in your opponent's papers and actions. There's almost always a defect. When they are using their fraudulent color of law on you, the court is void of jurisdiction. The court is void of jurisdiction when this happens, and can dismiss the case if you move the court correctly. It's up to you. You can make a claim against the bonds of the officials who have harmed you. No authority, acting outside of authority, equals void case, and you should win. And mind you, I believe I copied this word for word. So all these, anyway, but you will likely lose if you don't stay on this method and approach. No sovereign or patriot arguments, abandoning citizenship, etc. But it's up to you to find out and point out these issues, not the judge. The judge is there as a referee. He is not there to assist you in your case. He is not there to protect you, etc. I mean, he is supposed to be a disinterested third party. And because you guys have a controversy, now the reason why you're in court, I mentioned this on the child support video I just did. The reason why you are in the courtroom is because there is a disagreement between the parties. Somebody suing you, or you injured somebody, or something of that nature. And both parties' sides will need to be presented, and their evidence and their testimonies will need to be presented. And the judge rules on the weight of who has the preponderance of evidence. Look that word up, preponderance of evidence. If you put in more affidavits, more paperwork than your opponent, you are, by preponderance of the evidence, supposed to win that case. If they have more evidence and more documentation against you, they are supposed to win. So it's the preponderance of evidence that wins these cases. Got it? So now if you have evidence being shown against you, it is your duty to rebut it, get it dismissed, get it taken out of off the record. And big key. Thanks to Yusuf L for this one. Or was it, apologize, maybe it wasn't Yusuf L, maybe it was Jonah Bay. Either one of these two brothers brought up Trinzi versus Pagliaro. I will put that link to that case in this description below. Trinzi versus Pagliaro. Now, those that are lazy and won't even bother to click that link and find out what the hell I'm talking about, Trinzi versus Pagliaro, basically, I'm going to sum it up. A lawyer, a attorney cannot, or prosecutor even, cannot really talk in the courtroom. They are only supposed to submit evidence or bring someone to the stand to testify. So if they're in court saying, well, Your Honor, the plaintiff or the defendant, are you supposed to object? Is he putting anything on the record? Is he producing evidence? Is he producing a witness? He is not supposed to say a word, or he really can't say a word, because otherwise he's testifying. And if he's testifying, he needs to take the stand and be sworn in. So really gotta really look into, Google it, YouTube it, look into Trinzi versus Pagliaro. This will definitely help a lot of your cases, because if you can keep that lawyer, that judge, that lawyer, that attorney, that prosecutor from actually, like if you go to traffic court, and in traffic court, the prosecutor is presenting evidence, or he is making statements on the record. And in traffic court, you can shut it down too. Objection, Your Honor. Is the attorney, is the prosecutor going to take the stand? Is he going to be sworn in? Is he testifying? So you can literally blow him out the water, because unless he's going to produce a witness, or he's going to produce documentation, evidence, then there's nothing for him to say. And whatever he produces, you can object on that, because you want to actually verify the validity of his documentation. If he has an affidavit, is it signed? Is it sworn under the penalty of perjury? You got to really attack these affidavits, their processes. All right. So Trinzi versus Pagliaro, big jewel. Either it was from Jonah Bay or it was from Yusuf L that I bring this forward to you. All right. Who the hell is Jonah Bay? Who the hell is Yusuf L? You got some new people tuning in that don't know who the hell those people are that I'm mentioning. Again, I'll put links at the bottom. Every time y'all make a video, I do my best to leave links referencing what I talk about, who I talk about, and the stuff that I present. All right. So Jonah Bey and Yusuf El are two giants in the public and private realm. I'll leave it there, and I'll leave some information on them in the comment section below. So this document again is from urlaw.org, and it has to do with attacking the defects of the processes being used against you, and this can help you shore up your own processes. So number one, flaws in the complaint is applicable to civil and criminal cases. So if there's any flaws in the complaint, point it out, and that can end the case right there. All right. Is there an affidavit? Complaints must include an affidavit signed by someone who alleges damage, violation of their rights, a debt, etc. Something done by you that the man or woman, not just a statute violation, which is intended for government employees only. No affidavit equals defect. Affidavit must state who, what, when, where. Mere statements of violations of a code is defective. Was a defective affidavit, misinformation, or false testimony made before the grand jury or judge? That equals a defect. I'm not going to go back and read that over again. I want you to slow this video down, pause it if you have to, and reread what I just told you, what I just presented to you. Affidavits. A police report is an affidavit. Okay, moving right along. Assignments. If a debt is alleged, the complaint, the plaintiff, the original party, etc., or example, the original bank or institution that loaned you the money, if not, then demand a C, then inspect each assignment of the debt in the chain of assignments. See if the foreclosing trustee is even the proper party on the chain of title. If any assignment is missing, it equals a defect. Examine the dates of each assignment and when recorded. If not recorded or not dated, defect. They are not the proper party to bring the claim. So this can help you avoid foreclosures. Now, this could be over the heads for a lot of people. You may not understand the terminologies being used. I urge you to, again, pause this video and study each of these words in a legal dictionary to get a good understanding of what we're talking about here. All right. Now, what they're talking about for an assignment here, when you have a mortgage and it was signed over, or it was like the mortgage and the note must be together at all times. And oftentimes the note doesn't stay with the documents don't stay together. And usually when you apply for a mortgage, you apply for the mortgage and you also have the promissory note. At the time you are at the signing table or closing, you actually paid for your house. Then I got to make another video about that one to go through it, because I know there's a lot of questions about that. But all in all, those two documents must stay together until the completion of the mortgage is done. What they're doing is they're monetizing your promissory note, and they're making money hand over fist because the house is already paid for, and now you promised to pay, or they're making money off the mortgage that you signed. I might be mixing them up because I'm talking a little fast here, but when you sign the document, you put your autograph, your signature on that document, it becomes a negotiable instrument, and they make a deposit to get credits off of that. And you don't know any better. You now agree to pay X amount of dollars to repay a loan that you never got for the next 30, 40, 50 years, whatever term that you pick. So at any point you can challenge and request to see that note that you signed, and guaranteed if you turn it to the back, it's going to say paid to the order of. It's been deposited. It's been negotiated. But you can always request to see the original note. Now, if you're being brought into court for foreclosure, these original documents must appear in court. So if you have a case now, they're alleging that you owe X amount of dollars, request to see the note. request to see the documentation that you signed that verifies this debt. And if you notice a copy in the file, you must object, because a lot of times they don't know, they don't expect you to actually challenge these documents, which is why people are losing their houses. So when you request to see the original document you signed, the wedding signature, which I tell people all the time, don't sign in black. You're supposed to sign in blue, and you're supposed to keep that blue copy. They're supposed to get the black copy. Why? Because if any changes is made to the document after you leave the bargaining table or the signing table, anything they add to that document is not going to be on your original, and it's not going to be valid. It's going to be void. If you give them the blue copy, they can add anything. But I went over this another day. I'm not going to go over it again. But so the original document, you're going to request to see that, and they're not going to be able to produce it because they don't have it. And if they don't have it, that's a defect. You can win. So study this stuff. Look more into it. Don't believe nothing I say. Look this stuff up yourself. Any defects in the process causes it to be void. And if the judge overturns it, or if the judge accepts it, what you do is make a notation in that, like when you in court, you're not supposed to speak because they can't hear you. They need you to speak through a mouthpiece. That's their courts. This is their rules. This is how they do things. If you are able to speak in court, what you want to do is make sure you go on the record, for the record, on the record, let the record reflect. You want to ensure that your testimony, that your statements, that your evidence is being placed in the case. Because just because you present it doesn't mean it's going to be in the case. You, from experience, you're told to read the documents into the record. Don't just merely hand it over. Ask that you read the document into the record, and that's the best way to get it on the record. So when you look through the files that they're going to present to you, you don't find the original, you're going to challenge it. You're going to object to it. And now they must produce the original so it can be inspected. And if they can't produce the original, there is no case. All right, moving on. Do they have the original note? I just went over this. If they present a mere copy of a note only, defect. If certified copy of recorded note in 2/3 the size, defect. Okay, I brought some in another video as well. If the original note that you signed is on legal paper, 8.5 by 14, but the copy that they have in the file is 8.5 by 11, that is a defect. Void, void, void. It has to match. Like when you make a certified copy, and I mentioned this in, I can't recall the video, but if you make anyway, if you make as a notary, I can make copies of documents. So I have copies of constitutions and etc. If I make a copy of a constitution and the original document is on 8.5 by 14, the copies I make must be on 8.5 by 14. So you can't certify or make a true copy of a document if one page is 3 inches, 4 inches smaller than the other. That's not a true copy. All right. So when you go to court and they put the document in the as they present as evidence, but the original is 8.5 by 14, you got a 8.5 by 11 in the file. That's a defect. Call that out. Call that out. Okay. The number we down to 2. The court lacks jurisdiction over the subject matter. This is actually a defect with the complaint, the plaintiff, whether a person, corporation, bank, debt collector, sheriff, cop, lawyer, etc. If they lack subject matter, my brain is drawing a blank on how to explain to you how they would lack subject matter jurisdiction. So we're either going to come back to this, or I'm going to put some notation in the bottom of the video for you. Complainant has defective qualifications. Ask who is suing me. Who is the real party in interest? Do a FOIA request. That's a Freedom of Information Act request to the bar, to the bank, to the county clerk, to the judge, officer, etc. So we demand the qualifications. If an attorney, see if the attorney has a real license, not a bar membership, so-called license, then go after their bond or lack of oath or lack of oath on record. If not, defect. Complainant has no standing to sue. If a corporation, verify if the corporation is registered in the state to do business. If not, defective, no standing to sue. If you are being sued by Capital One, Bank NA, and, or let's do it, I got a good one. You took out a payday loan. You took out a payday loan from Red Flag Funding, and you happen to reside in the state of New Jersey. Red Flag Funding is operating out of Michigan. Red Flag Funding does not have a license to operate in New Jersey. They have no standing to sue you. They weren't supposed to be doing business in New Jersey. Now, they never stepped foot in New Jersey. However, they're doing business with an individual. And if you do it online, you know, there's different criteria that needs to be met. But most of the time, if they do not have an office, if they don't have jurisdiction in your area, then they don't have standing to sue you. Think of also, what court are they bringing you to? What if they're suing you in a Michigan court or Mississippi court, whatever, in their jurisdiction? That's out of your jurisdiction. You're like that. I guess you see what I'm saying. You reside in New Jersey. You apply for the loan online, allegedly. You know, they have to have an office where you are. They have to be able to do business where you are. All right. If not, defective. Court lacks personam jurisdiction. Good one. Again, personam and subject matter. The definitions escape me at the moment to explain it to you, but do a search on your own. Figure out what it is. I'll do my best to explain it in the box below. You do not understand. Never say you understand anything. Ask questions in response to a judge or prosecutor's questions. When you say you understand, that means you submit. When you say you understand, that means you submit. That means you're waving the white flag, you've given up, you've actually went over to the other side. Got it? Never say you understand. No, Your Honor, I do not understand. I do not. It's not that I don't. I can't. I can't pronounce, or I cannot make out what you're saying. It's not about that. I do not understand. Like, I need to further illustrate this for you. Let me find a way to put it. It's not that you are incompetent. It's not that you are illiterate. It's not that you are a minor. Look these things up. These all make sense in a law dictionary. You do not submit to their jurisdiction. You do not submit to their authority. You're not challenging their authority. You could challenge jurisdiction at all times. At any time you can challenge jurisdiction. But when you say you do not understand, that means you're not giving up the fight. When you say you understand, you more or less gave up the fight. All right. And these are court tricks. So you need to understand, or you need to overstand, understand what they're asking you, what they're asking you to surrender when they're asking you, do you understand? All right. Next, you are only there due to threat, duress, coercion. Now, say I can't participate in this matter at this time because I have to know who issued this summons using threat, duress, and coercion. Threat, duress, and coercion voids any presumed contracts and therefore lacking jurisdiction. You know, use these terms. This stops them in their tracks in these courts. Court lacks subject matter jurisdiction. Then we just court lacks subject. Oh, I'm sorry, they just requoted it. Okay, can this particular court hear this type of case? If you are in a civil court and they're prosecuting a criminal matter, it's wrong jurisdiction. Just like you can't go to bankruptcy court and talk about traffic tickets. You can't go to traffic court and talk about bankruptcy. You have to be in the right venue and handle the right type of case. All right, I think we cleared it out. If you don't understand, ask questions, and I'll try to clear it up. Okay, procedural errors. Laws dictate how long certain actions have to be performed. Look for dates, time stamps on papers for timelessness of actions. Actions beyond the time allowed is a defect. Lawyers get in trouble for this a lot when they are supposed to answer like if you have a lawyer you retain a lawyer and you are supposed to answer, you're the defendant, allegedly the defendant, and you are supposed to answer a summons or some kind of charge, and you had 30 days to do it. The attorney doesn't answer until the 32nd day, which causes you to, fall into default. These things get you in trouble. It hurts your case, and lawyers can be brought up on charges for that. So timing is of the essence. That is an equity thing. The court doesn't reward those that slumber on their rights. If you get a letter from a bill collector, debt collector, whomever, and they say you have 15 days to respond, and you respond in 17 days. Yes, you responded, but still you responded after the fact. So just because you responded doesn't clear up the response or the lack of responding in a timely manner. It can hurt you if they use that against you. All right, procedure errors, flaws in the warrant. Warrants must have wet ink signature, not a rubber stamp, plus an attached affidavit and an attached complaint by a real damaged party. A living man versus you, a living man or woman. If they are entity, the state of, corporate entities, governments can only make complaints against corporate entities. The state of New York can't sue you. You're not gonna catch that. The state of New York can't sue you. When you see those, the people versus this and that, these things are flaws that you need to expose. They're getting away with this stuff because you don't know. And lawyers, attorneys are part of a three-ring circus. The lawyers or the prosecutor, the defense attorney, and the judge are part of a three-ring circus. They're there to do a show on you. So they're in cahoots, and they don't have your best interest at heart. So you got to know these things. You got to know the tricks of the courts, and you got to use these things against them. So a warrant, if someone comes to your house, whether it be a warrant officer, a sheriff, a marshal, police, when they come to your door and say, we got a warrant, search warrant or arrest warrant, okay, can I see that? I need to inspect that. You want to make sure that it's actually signed and not rubber stamped. You want to make sure it has an affidavit attached to it. And you must exercise your rights. You tell them, yes, I see the warrant, but where is the missing parts of it? It needs to have an affidavit. If you don't know this, you don't know what to say. But now you do, you know what to ask. All warrants must be accompanied by an affidavit. They must be together. If not, it's not a valid warrant. They can't leave the affidavit at their office and bring the warrant to your door. No, they can't. So they bang on your door all they want. They produce a warrant. Now, if they have a search warrant, most of the time, they're going to bust your door down and they're going to make their way in. And then they're going to, tell you we got a warrant. And they're going to wait until they have you secured and the whole nine. And most of the time, they're going to wave it in your face. You have a right to inspect that warrant. And it must be attached to an affidavit, or affidavit must be attached to it. All right. So perhaps I'll do a separate video on that altogether to explain the warrants and all that. You need to know this stuff. So just because they show you a warrant does not mean, okay, you are pulled over, you're driving, you're traveling, and they request to search your vehicle. You tell them also, no, you're gonna need a warrant for that. And if they say, okay, we'll wait until we get the warrant. So they're gonna detain you until they get a warrant. They're gonna come to you and bring you this piece of paper that says warrant on it and all this fancy letters. You're gonna think it's legit, but guess what? There's no affidavit. You need to know, like if you know these things and you present it to them, they can't bullshit you. But if you don't know and then they just drop some document, bring it to you and say, okay, here, we got the warrant. Oh, okay, I guess you can search. Now you just gave them permission because cops are allowed to lie to you. Did you know that? Police officers, law enforcement are allowed. The Supreme Court ruled on this. They are allowed to lie to you. They are allowed to lie to you. Investigators, detectives, they are allowed to lie to you. But it's against the law for you to lie to them. Crap, this is a load of crap. But anyway, so make sure that that warrant is attached or has a affidavit attached. All right, the warrants, missing wedding signature of proper official, defect, affidavit defect, missing affidavit is a defect, not sworn or notarized, affidavit not sworn under penalty of perjury, it's a defect. Not a real affidavit, just a writing. You have to excuse me. This is exactly how UR Law presented it, but they were explaining it. I know it's being said because I watched the video and I'm familiar with the terms and what they're talking about here. So you may not understand this, but I'm going to keep going and hopefully you understand or you get what's going on here. The signature, affidavit missing a real wet ink signature. It's a defect. Defective contents and statements. Affidavit fails to state who, what, when, where is a defect. Some affidavits only claim that the defendant generally presumed to have violated some law or code. This is defective. Codes only apply to agencies and government employees and persons, not people. If you notice there is a law that says no persons shall do this, who are they talking about? They're not talking about you. You are not a person. Or are you? If you don't know who the hell you are, I can't help you. You need to know who you are and who you are not. Laws are made to stop persons from committing crimes, to stop, I can use even individuals from committing crimes. If you do not fall into those categories, then it doesn't apply to you. You need to know who the hell you are, and you need to know how to defend yourself. So when you see, and even look up law, look at the statutes, codes, and ordinances and what they're writing. Like, how can you be charged with a crime that you know nothing about? You know more about power and housewives and all these ratchet shows, but you don't know statutes and codes and ordinances that are being used against you. That's your fault. That is your fault. You need to know this stuff. You need to have a working or a general knowledge of a lot of things. Now, I should do a video on that one. That just came to my mind. What general statutes and codes and ordinances should you be aware of that are generally affecting our people? What do they usually use against us? What are the defenses for them? I think I'm gonna do that video. I'm putting that together for you guys. But moving right along, flaws in personnel, all those involved, the jailer, the sheriff, deputy, it goes about their bond. I'm gonna skip that. Authorization, oath of office or record. Good one. If you are pulled over by by law enforcement, if you had a search warrant executed on you, etc., pull the oath. All officers take an oath before they get to office. All public officials take oaths. Make sure that they have an oath on file. If they don't have an oath, they weren't sworn in. I've worked for a state agency, and some of the processes they did out of order. I was operating state vehicles before I had certain clearances. That's not totally true. I'm just painting a picture for you guys. If there's a flaw in the process, it is void. So you have an officer that is walking the beat, or he is on the job, and his license, or a security guard doesn't have the proper credentials, his SOAR license or his security license is suspended, expired, revoked, then he does not have the right or the permission to do his job. He shouldn't be at work. He should just same with the officer. If an officer doesn't have an oath of office on record, he should not be in that patrol car. He should not be on that beat. There are things that if they're missing, he can't be a viable public servant. All right, so you need to challenge these things. Move right along. The bonds, that's a good one. I'm going to just skip over that. Other qualifications to hold office, we're going to skip over that. We're going to the general process in using this information. Key is to point out their defects on the record. Point them all out. Keep pushing for dismissal. Hold them accountable to the rules that bind them. You're in court, or you're being adjudicated because you didn't follow some kind of rule, statute, or ordinance. Well, there are codes and ordinances that they have to follow as well. So that's like an officer that drives around all day long talking on his cell phone, but he pulls you over for talking on your cell phone. Every ticket he wrote is null and void. He does not have special permission to talk on his cell phone, and you don't. So same here. If their information is not up to date, then they can't be enforcing any statutes, codes, or laws against you. They got to be right before they come to you. Do an abatement of the matter before court. Sending it back to the court and declaring your status as a non-fiction entity, including your affidavit of status as well as you have one. This works, but you still may need to be ready for a more complex battle. This is true. I got a speeding ticket in, can't remember the town at the moment. I was allegedly clocked doing 93 to 65, and I abated that ticket. I sent them all this information in that I denied corporate existence. I denied this, I denied that. I rebutted the affidavit that I was speeding. I rebutted, and I more or less won in the paperwork. I was compelled to drive 4 hours back to this damn town, Phelps, New York. I was compelled to drive back to this town to be in the courtroom to actually, fight this case. This is before I knew what I knew, but I had a little bit of understanding of the law and how the process goes. So I went to court, did a special appearance and the whole nine, and I sent them notice that I was going to be in court, but I was going to make a special appearance or special visitation. No special appearance, special visitation. And there was an officer in the court, wasn't the officer that pulled me over, but when I ultimately got there, I was the last one up to, the case was the last one to be heard. They told me that the officer didn't show, so I guess we're going to have to dismiss this case. Right. They ain't want no smoke. Anyway, writ of mandamus to enforce FOIAs. You do a writ of mandamus to make sure you can get the Freedom of Information Act documents that you request. What is a writ of mandamus? Google it, look this stuff up, all right? Publish public notice of results. If you win your case, I did a 93, or allegedly did 93 to 65, and I successfully won my case, we are supposed to publish these victories or these decisions because they're not doing it. What happens is often they have all of their victories of us being convicted for speeding and for doing this, but their record is not being put out there on the record of these cases being dismissed, or their F-ups, as I'm going to call them. So you're supposed to make this public notice to let the public know, yeah, another victory on our end, we got them. So powerful information that UR Law is presenting here. Criminal complaint. Very powerful method. This is a sham legal process. Jurisdiction, defects, or any collection, mortgage, tax, traffic issue, then they will negotiate without court, or you will have leverage if you do not go to court. You'd have to go back up and read what they're telling you. So this template is for those that are actually fighting cases, preventing cases. These are giving you strategies to attack the defects on the presentments that are made, the charges that are made. There's almost always a defect, whether you were improperly served, whether you didn't get proper notice, whether you they spelled the name wrong. If they use your all caps name, I happen to have my all caps name copywritten. I have a DBA. I'm doing business as. If they were to send me some kind of notices, summonses, whatever, I can tell them to cease and desist using that name. You know, use the license plate. You know, don't use my name. You know, I can make them not use that name. If you remember, Prince at one time stopped using it because he didn't own it. You know, he felt as a slave because he didn't even own his name. So I own that name and I control that name. I don't want them putting my name on any documentation, and I can make sure that they don't. And you can do the same. Make a claim as a new suit. Let me read what they say. You must go on offense right away, but first provide an adequate administrative process. Look up my video on administrative process, see what they're talking about. And establish a reason and record in the record to sue. If you have time, you must exhaust administrative remedies as a prior to a suit. A key to use before entering a suit is to learn procedures using UR law. This is a required study and foundation study before beginning a lawsuit. And I'll briefly touch on this. When you do an administrative process, you send them documentation, preferably through a third party or through your notary. And your notary is a third party when means. So the first party is them. You are the second party, or the first party is you and they're the second party, whatever. The third party is the notary. The fourth party could be the post office. The post office is a witness because they are serving your process. The notary is a witness because he is actually delivering your documents to the post office, or he or she is examining your process. They know what's going on. They are watching you swear on your documentation that something took place. They are a disinterested third party. They're not your best friend. They could be, but don't say anything. They are not your best friend, so they are a disinterested third party. So now when these documents are sent on your behalf, your notary is the one that they must contact. So if you are sending it to Capital One NA, they are supposed to respond back to your notary. And if you also wish to, they can copy you as well. So they would contact your notary and copy you. This is proof that they are responding to you adequately. If they don't respond, your notary is a witness to say, well, I didn't receive anything. So they didn't respond, and he can go to bat for you. So that's how you get your default. If they don't adequately respond, or if they don't respond at all, that's why you need to use a notary. Now, you must exhaust your administrative process. If you send them something and they do respond back, it's playing tennis. You hit the ball back on their court. You wear them out, because trust me, they're going to try to wear you out. Once you wear them out and they no longer respond, or they can't respond because they don't have standing, you get the default. And now you immediately take them to court and you actually sue them for a monetary number. And when you sue them for a monetary number, they're going to fold and they're going to try to settle with you. So this is how you get paid on these transactions, as opposed to letting them screw you and you paid all this money and legal fees and all this court costs and the case gets dismissed. You got time off from the job. You paid all these legal fees. You came out of pocket, and now there's no victory in your end. However, if you sue them and you make them come out their pocket, they are not going to do this to you again. And chances are they're not going to do it to the next person. But no, chances are they are. They're going to look for the easiest prey and they're going to eat them alive. don't be prey. So I think we've done enough in this video. I didn't want to make it 2 hours long. This is a document that I came across from UR Law. It's about attacking the defects and processes. It is a very powerful piece of work that they put together. Kudos to them. And I hope this video helps you in your endeavors, all right? So please, if you haven't already, click like, click share, leave me a comment, let me know how I'm doing. You know, tell me I'm doing bad. Tell me I'm still saying, you know what I mean? But always, I thank you for your time. I thank you for the comments that I do get. I thank you for those that click subscribe and like these videos. I appreciate you, and I'm doing this for you. I'm doing this because I don't have any debt and I don't have any issues, but I've been doing all this study and I don't have anything to use it on. So that's why I've been doing my friends and family's paperwork to help them get out of issues, and I've been doing very well on this. So I'm here to help you get your issues resolved and get these monkeys off your back. So thanks again for listening. I appreciate you. And until the next time, peace, everybody. Peace.